Tomorrow, the U.S. Supreme Court will take up the issue of birthright citizenship. It's a topic that we explored on the show a couple of weeks ago in anticipation of what's to come. To recap, the Trump administration argues the 14th Amendment's guarantee of birthright citizenship was, in the president's words, because of slavery, meaning its sole purpose was to enshrine citizenship into law for former slaves. The because of slavery argument became popular with a book called Citizenship Without Consent, and it was published back in 1985. But expect the administration to go back to the future when it makes the case to the High Court. Joining me now, once again, Professor Paul Finkelman of the University of Toledo School of Law. Professor, welcome back to CTW.
It's a delight to be back here.
Longest addition to the Constitution. It covers multiple subjects, and that's going to make interpretation not only difficult, but potentially very political. What will you be listening for during oral arguments?
I will be listening to see how the government makes the claim when the language of the 14th Amendment is very, very clear. The 14th Amendment says, and I will read it, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The clause subject to the jurisdiction simply means that a diplomat would not be considered somebody who is subject to the jurisdiction. Everybody else in the United States legally is. The language is quite clear. So I am curious to see how they will try to explain that the language doesn't mean what it says.
So the argument on the other side is there was no deportation, no so-called illegal aliens back during that time. You've written extensively on the fact that there were a number of cases in which there were people that were considered in the country illegally, whether they be blacks that came from other parts of the world, the Caribbean, or whether they be immigrants that came from Germany and other places that fought during the Civil War. And the framers of this amendment took all of that into consideration. Is that a compelling argument here, or do the politics of the moment risk sort of taking all of that precedent and wiping it away?
I hope the politics of the moment don't lead to the court saying that clear language in the Constitution doesn't mean what it says. The other point is that the Trump administration has been trying to deport people on the grounds that they are enemy aliens using an act from 1798. Under the Alien Act of 1798, you could order somebody to be deported if they were an alien enemy, that is, the citizen of a country at which we were at war. But if that person evaded deportation, stayed in the United States, and later had children, those children would have been citizens under the 14th Amendment. So the argument that there was no such thing as an alien who was not entitled to be here is simply nonsense. And the Trump administration constantly uses a law which created that status.
Professor Paul Finkelman, always good to see you, sir, and thank you for your time.
It's always a delight to be here. We'll see what happens tomorrow.
Indeed.